Why do defense attorneys agree to continuances for detention hearings? It's simple. They're not ready to go on the day that the client gets arrested. And it's very common. Whenever you propose a bail package in federal court, whenever you go to a detention hearing, you have to demonstrate to the judge that there is a set of conditions that would assure the safety of the community and the person's return to court. And you also have to demonstrate that the person is not a flight risk and that the person will come back. And when we're going to a detention hearing, we need to have a proposal for what is a reasonable bail package. And you don't just get to show up and make up numbers and propose something that you can't deliver. So ultimately, the defense attorney has to speak with family members. The defense attorney has to figure out, is there a secured portion of the bond that the family or the client is able to do? And is that cash? And if it's property, it gets a bit more complicated because then you have to figure out how much equity is in the house. And under 18 USC 3142, which is the detention hearing statute, the prosecutor can ask for a continuance for up to 3 days. Defense counsel can ask for a continuance of up to 5 days. And ultimately, this does not include weekends, this does not include holidays, but ultimately, if you're going to a detention hearing, you need to have a plan. You need to speak with family members, you need to have their names, their jobs, their phone numbers. You need to know who's co-signing for this bond. And if you're not ready, it's not going to be beneficial to anyone. You need to have something that is well thought out, put together, and you pitch the judge on this proposal. And typically, a lot of defense attorneys ask for a continuance, maybe not the whole 5 days, but sometime just to get everything ready. And a lot of the times when the clients get arrested, the lawyer, when they get notified to come to court, the lawyer has not spoken to all the family members. The lawyer has not gotten everything in place. And it's not like you get a heads up that you're going to be arrested by the feds unless this is like a very slow, drawn out, voluntary surrender. So defense lawyers agree to continuances when they're not ready, and you don't get to go back to the magistrate to say, Judge, we're ready now, if you already did a detention hearing and if you're not successful. So you agree to a continuance, maybe not the whole 5 days, but sometime, just so you're ready to go, so you don't blow your one shot with a mag judge.